How's everybody doing today? Today's topic is finding the right attorney. So what do you need to look for in an attorney for your custody case? Well, some of the most important traits to look for, of course, are credentials, experience, a personality and style that's going to complement you, a track record and a history in dealing with your judge and opposing counsel, and someone with whom you can agree on the strategy and tactics for your case. It's important to know if they're good negotiators or if the majority of their cases go to trial. So let's begin with credentials. First and foremost, you want to make sure that at minimum they specialize in family law, divorce, and custody cases. So you want to look for someone who has a designation as a certified law specialist, a CFLS. Now on top of this, you may also want to look for an attorney who's a member of the American Academy of Matrimonial Lawyers, or the AAML. Lawyers who are part of the AAML, they have to be chosen by their peers. They must have significant experience with large, complicated cases, and they're members of an elite group of lawyers who are really on top of their game. So if you want the best of the best, you want the AAML lawyers. Now, while designations are significant, it's only part of picking the right lawyer for you. Experience and background are equally important. And when interviewing prospective attorneys, find out how much of their practice is dedicated to family law and child custody issues. You should ask what type of track record they have and if they have experience in cases similar to yours. Ask their opinion of your case and what they believe the likely outcome is. You should also find out what strategy they would use if retained by you and what are the strengths and weaknesses of your particular case. You should know what their plans are for reaching a settlement, and if a settlement isn't possible, what's their trial experience? Ideally, and this is the most important, if possible, you want a lawyer that has experience dealing with your particular judge. If your lawyer knows and has rapport with the judge, it's going to make a huge difference. It can save you time, money, and give you a great advantage. During my divorce, my ex's lawyer didn't know the judge, and she used a tactic that completely backfired. The court changed judges in the middle of the case, and her attorney, without knowing the new judge, tried to dramatically make their case that I was the one dragging out the case and needlessly running up legal fees. So her attorney wheeled in a cart with 12 banker's boxes of legal documents. Well, the judge saw this and shouted, "This ends now." Needless to say, her theatrics helped my case because her attorney just didn't know the judge. Now, another question you should ask when interviewing attorneys is if they have experience dealing with opposing counsel. If so, ask them about their experience with them. Have they ever worked with opposing counsel? And if they haven't, at least make sure they at least become familiar with their track record and their style. Now, aside from gathering information on a prospective lawyer's background, reputation, and track record for settling cases, you should also take into consideration their attitude and their style. Some lawyers will assume that you're going to BK, file bankruptcy, before it's over. And especially if they see a high degree of conflict and a non-willingness to compromise, they may demand large retainers up front. And instead of trying to diffuse the tension and negotiate a compromise, they might actually fan the flames of anger and resentment. "Don't worry, we won't let her get away with that." It's best to avoid this type of lawyer if you want to emerge financially solvent with a reasonable settlement. Also, if they believed you'll be forced into bankruptcy, it may influence how they try your case. Once your funds run out, they may put their effort somewhere else, or they may get rid of you completely. They may give up or fire you. Now, attorneys can and do fire clients. And while it's in your attorney's interest to win your case, your financial position may have a direct relationship on their strategy. Now, attorneys have an inherent conflict of interest. While on the one hand, they want to win, on the other hand, they may be pressured by their firm to bill as much as possible. And this is a reason why a custody coach can come in handy, because you're on the same side of the table and they're not trying to run up fees, but that's a little aside there. But anyway, you're better off with an attorney who's good at negotiating and settling. This is going to decrease your chances of filing bankruptcy, even if opposing counsel is overly aggressive. Now, it's not always possible. It's better to avoid going to trial. In fact, most courts require mandatory settlement conference meetings with mediators, And this helps them save time as well as to see if you can work things out between yourselves. Of course, this is the best way to go, but if the other parent is unreasonable, it may not just work out. But you should use this resource to save yourself time and money if possible. But once again, you always want to settle, because think about it. Who's going to know what's best for your kids? Do you want to make that decision, or do you want the court to make it? It's very rare that the court is going to make that decision and you're both going to be happy with it. And as much as you may have anger and resentment towards your ex, it's still better than letting the court get in the middle of it. Because in the end, divorce is about dividing up families and assets in a reasonable and hopefully fair manner. In other words, it's about compromise. And divorcing parents rarely get everything they want. So to avoid getting dragged over the coals by your lawyer, the court, and the other parent, you may want to really try to negotiate and settle this. The longer that custody and divorce drags on, the worse it gets. Now, the judge wants you to get through the process as quickly and fairly as practical. And if the judge perceives you're being unreasonable or dragging your feet, it's going to reduce your chances for a good settlement and increase your legal fees. A good attorney is going to help you move through the process at a reasonable pace, and in the end, make you feel like you reached an equitable compromise or settlement. Choosing the wrong attorney is always going to cost you more, not just financially, but also emotionally and how you feel about the settlement. And one of the other casualties of divorce, you don't want to hurt the kids, but you also want to keep your sanity and you want to keep your financial stability. So choosing the wrong attorney is going to hurt you in all three areas. What else is choosing the wrong attorney going to do? Well, it's important to find the right lawyer. It's even more important to avoid choosing the wrong lawyer. If you're unreasonable in the eyes of the court, even if it's on the advice of your lawyer, it's going to cost you in a variety of ways. You should view your lawyer as an expensive employee. If they're not doing the job you want them to do properly, it's going to substantially increase your legal fees. So please choose them carefully. Make a realistic effort to educate yourself, at least on a basic understanding of how family law works with respect to custody. Don't use your lawyer as a therapist or for emotional relief. This is going to prove to be a very expensive misallocation of resources. One more reason why it's better to have a custody coach who's not an attorney. Now let's talk about that, running up legal fees. I don't care how much it costs. I want them to suffer for what I did. Other than the delight your attorney is going to express when they hear such things from you, this statement demonstrates the wrong attitude, and it's going to get you both in trouble and going to cost you in the end. I'm the mother, so I deserve the bulk of custodial time. He makes more than me, so he's going to be paying my legal bills. I'm going to accuse him of everything under the sun. Well, the legal firm of this is yours and that's mine loves to hear statements like this. Now, many fathers also initiate expensive battles to be the primary custodial parent in an effort to reduce support payments. Now, unfortunately, many mothers use increased support payments as their motivation for not agreeing to joint custody as well. In states like California, it's easy to take this tact as support's based on the amount of custodial time you have with your child. But this is a mistake. I knew a dad who wanted to be the primary custodial parent, and even though he wasn't available during the week and living in his girlfriend's trailer with her kids, he still wanted to do that to minimize support payments. Well, guess what? Not surprisingly, the judge didn't agree. Now, some states will make you responsible for paying the other parent's legal fees, and it's not only based on your ability to pay, but also if they feel you're the one unnecessarily running up the cost of litigation. And this is true, once again, even if you're only following the advice of your attorney. Now, during my divorce, my ex outspent me on litigation 4-1, and I earned double what she made. But in the end, I was only required to pay a fraction of her attorney fees, despite her ongoing request for me to pay 100% of them, because I always tried to negotiate and compromise. Be sensible, and here's the best advice I can possibly give you. Take the high road. Try to minimize your legal expenses. Try to compromise. Get out of the system as soon as possible. Don't let the court make decisions for you. When it's over, you're going to be very glad that you did. Anyway, that's it for our segment on choosing the right attorney. As always, if you have any questions, feel free to email me at joe@platinummethodcoaching.com. Until next time, make it a great day.